Okay, good evening. Today we are going to discuss KB3 business law under the syllabus of the Chartered Accountants. We are going to focus here on the company's law in general as well as under the law of Sri Lanka. So let me first of all take you through the contents of which I am going to lecture in this lecture series. It will be on the introduction to the subject, and then on the history of company law, the nature of personalities. Personalities distinguish corporate personality and the company law, and Solomon and Company Limited case, which is considered a landmark as long as the company law is concerned. Thereafter, I will be taking you through the rest of the contents in this lecture series. First of all, let me give you an outline of the introduction to the subject. First of all, I would like to address you on the emergence of business through sole proprietorship and partnership. In the past, most of the business activities were conducted solely by oneself or collective of few people together. When a business is conducted solely by one person, we call it a sole proprietorship. So all the business activities in that model are conducted by one person in his own name and style, or a name that he adopts for the particular business. In that context, a proprietorship involves liabilities upon oneself, the person who conducts the business. All legal and taxation matters come within the purview of his personal liability. With time, people moved into partnerships where they collectively engaged in a business with several persons getting together for what we call a common objective. In realization of this common objective, they tend to operate that particular business collectively, so that every partner to such a business were considered individually responsible and liable for the businesses and the transactions they were involved. And even the taxation were primarily on the personal liabilities. In the past, most of the businesses were self-funded, or it tend to mean that a person funding towards a business by himself or herself without any participatory involvement of the others. But with the growth of different business styles and models, this participatory type of collective engagement came into being with the support of the regulatory and statutory framework that implies legal principles towards such a business. Especially in the case of requirement for capital growth, these businesses spread into a much wider scope, and the technological development pushed these businesses forward, that collective governance was tend to be of immense necessity. Therefore, the traditional approaches such as the ecclesiastical or monastery-based engagements were developed, and especially in the United Kingdom and in developed economies, these were supported by the Crown and other means of governments, so that these businesses became much wider in scope as public enterprises, or what we call the public bodies, that tend to expand them into kind of guilds of merchants, where the merchants got together and formed their own associations, such as chambers and trade associations, that in fact obtain the charters of the Crown. And in England, we saw how supportive was the Crown towards bringing in these business entities into much wider type of trade associations and guilds. In creating differences between unincorporated bodies and incorporated bodies, this area of business was very much focused in the 1750s, of course. Around 1750s, the business community understood that it is important for the businesses to grow without any discontinuation and collapses, so that indefinite existences of these businesses became imminent, or what we call the perpetuity. And also, those who were engaged in these businesses wanted to leave out their liabilities towards these organizations, so that personal liabilities upon themselves became quite minimal. They in fact wanted to have exoneration of liability, an exception from liability in case of business activities that they took up. So they were in search of models that could give them exoneration of liability, especially letting these businesses operate on a side, having the title to sue and be sued as of a person, as of a natural person. We know that when a person is engaged primarily by himself in a business, in a proprietorship or in a partnership, as we discussed before, the liability falls onto themselves personally, so that they become subject to legal actions in their own names and styles in case of a partnership. But however, creating an incorporated body would mean that such an incorporated body would take up the partnership to its own and leave out the persons who are involved in the business aside, and let that particular incorporated body to be sued or sue in its own name and style. This emergence gave much confidence and liberty to the people who are doing business. And also the other fact is that these business corporations could limit the liabilities as a means of protecting these organizations for the future growth of the industries. So with that, company or companies came into existence. Much of the difficulties centered around the fact what a company really means or how to define a company. The name company derived from the Latin term com, that means with or together, and pani, with the meaning bread, collectively meaning having meals together, so that the persons who are involved in a company can have the meals together and let the company operate by its own, serving the purposes for which it has been created or constituted, and keeping the creators aside as far as its personality is concerned. So, a company became a distinct personality from the individual members or persons. Now, I would like to emphasize this with a small example. Say a person A and person B would like to form an association such as a company. They get together and form this association, but this particular association will have its own personality, such as personality C. So, this distinct personality will operate outside these two individuals as one entity of its own. This is the basic concept of a company, that a company can act by itself without the involvement of these individuals who are inside the company or who are the creators of the company in a more legal environment. Obviously, functional capacity would be that these two individuals are the real operators of the company. But however, the company exists as C, distinctly and separate from the natural persons of A and B. So with that concept and the legal structure involved, the evolution of classical companies tend to happen. One of the classical companies that we can take as an example is the British East India Company, formed in around 1600s. Now, Sri Lanka has a very close relationship to this British East Indian Company because we were a colony of the Dutch during that time, and the Dutch controlled Sri Lanka or occupied Sri Lanka as a company run by a state run by this company, the East Indies Company, which was later taken over by the British and created the British East Indies Company. Adam Smith in 1776 in The Wealth of Nations explained what a company is. He goes on to say that the directors of such companies, however being the managers rather of other people's money than of their own, it cannot well be expected that they should watch over it with the same anxious vigilance with which the partners in a private company frequently watch over their own. Like the stewards of a rich man, they are apt to consider attention to small matters as not for their master's honor, and very easily give themselves a dispensation from having it. Negligence and profusion, therefore, must always prevail more or less in the management of the affairs of such a company. It is upon this account that joint stock companies for foreign trade have seldom been able to maintain the competition against private adventurers. Now let me take you through this definition and clarification of Adam Smith in a more illustrative manner, where he says that the directors of such companies, directors means the people who are operating once as agents of the company, and on the other hand as the managers of the company, where they manage the functionaries of the company. However, it further says being the managers rather of other people's money than of their own, means that other people's money means the people who have invested, like that A and B I took as an example, being the shareholders, or the people who invest towards these companies' business goals realizations. It cannot well be expected that they should watch over it, which means that the directors are there to watch over the functions and the affairs of the company with the same anxious vigilance with which the partners in a private company frequently watch over their own. That to mean that the directors are really the agents of the shareholders, but operate in legal sense as the agents of the company, such as the example of C. Like the stewards of a rich man, they are apt to consider attention to small matters as not for their master's honor, which means that the directors are acting on behalf of the company or representatives of the company, and not merely on the commands of the shareholders or the investors, but for the entire benefit of the company itself, and very easily give themselves a dispensation from having it. Negligence and profusion, therefore, must always prevail where the directors tend to operate as responsible persons, employing the relevant skills and competence to look after the interest of the company, the beneficiary, so that they are not tend to act in a manner negligent or in detriment to the company's well-being, and very easily give themselves a and therefore must always prevail more or less in the management of the affairs of such a company. It is upon this account that joint stock companies, the joint stock companies that prevailed in UK or the United Kingdom in the past, are now considered under the Companies Act for foreign trade have seldom been able to maintain the competition against private adventures. This is the advantage of having a company, that they have an edge over the private individuals that are operating in the business world, so that the companies can have a perpetual existence, or what I called the existence as a indefinite person having perpetuity. If you look at the modern companies or the evolution of modern companies, in the past we had the Joint Stock Companies Act in UK that is considered as the classical model of company law, which came into being in 1844, and thereafter it was further modified by the Limited Liability Act 1855, and thereafter the Joint Stock Companies Act 1856, and later on titling itself as the Companies Acts or Laws, where the most modern one being the Companies Act 2006 in UK. If you look at the Sri Lankan examples, we do have the same models as introduced in the United Kingdom, especially because we being a colony of the UK, of the British in the past. The British introduced their same Joint Stock Companies Ordinance in Sri Lanka, quite similar to that of the Joint Stock Companies Act in the UK. But however, after Sri Lanka became a republic, in 1982 we had our first Companies Act, which is quite a homegrown solution, but well established, well dependent on the English legal cultures and the English legal traditions. And now we have the Companies Act number 7 of 2007, which is a follow of the Canadian model we call, and that governs the entire companies law area in Sri Lanka. Now, before we go into more details, I would like to emphasize the Sri Lanka's history in venturing into companies. As I mentioned before, Sri Lanka has adopted the law of the United Kingdom that prevailed in the past, and it has recognized the legal personality of companies apart from natural persons. It readily accepts the importance of investment on companies by way of shares by the shareholders and of the labor, the working force in such an organization, administered through the so-called directors that I explained, and management affairs by the shareholders and directors, either individually, independently, or collectively, but as a board or in the general meetings of the shareholders and directors. And all these individuals acting in the capacity of shareholders and directors are meant to act in good faith for the benefit of this distinct personality so as to be beneficial towards it and to protect it from any misconduct or liabilities that that legal person, what we call, will have to face. And if you look at the new outlooks in Sri Lankan companies and the transformation of foreign ownership, especially in the context of foreign investment and having offshore companies of other countries in this country as investment models, and for the growth of national economy, there are many sellouts and buyouts that take place by way of sell and buying of shares, so that the owners of the companies change, but the company still existing in same style and names. Even though we saw in the past that leading companies were of more foreign owned, falling from the various family dynasties, still the names, some of the names like John Keel's, George Stewart's, and many other to name exist in this country. And Sri Lankans have happened to own the shares and transform into their own companies with management transitions, takeovers, acquisitions and mergers. And presently, we are in the process of attracting more and more foreign investment into the country through various investment opportunities that these types of models offer to the entire world. So the importance of companies can be very readily felt in our society, and this will, however, grow from strength to strength, and many new areas connected to companies will be seen in the future as well. Now let me take you through the history of the company law in general as well as in Sri Lankan context. In general history, as I mentioned, the history of companies derived from the word corporation, which means that it's a collective association of individuals cooperating with each other, joining in a kind of association to form a distinct legal authority. And this term, as I previously mentioned, derived from Latin, as well as the term of corpus, that consists of a body of persons and dates back to the reign of Justinian, the great Roman emperor, where the Roman law recognized a range of corporate entities under the names of universitas, corpus, or collegium. One famous example of a later development was the East Indians Company that I mentioned beforehand, of the Dutch, through which they made colonialism in the East, including Sri Lanka. In the medieval period, government and local authorities were created as companies such as the Pope of Vatican and the City of London Corporation, and companies that came from the charter of the king or the monarch, as I previously mentioned, such as Stora Koppenberg in Sweden. Sri Lankan history of companies, as I in fact previously mentioned, derived from the United Kingdom, that introduced in 1837 and later improvised and legalized through the Joint Stock Companies Act, Chartered Companies Act, where companies formed under a seal. First law was Joint Stock Companies Act 1844, the English law, where liability was unlimited. Now here, having said that the liability is unlimited, it is same as the model of a sole proprietorship or a partnership that we discussed. Further developed through the Building Societies Act 1874, 1894, 1939, and then the Companies Ordinance 1948 as a consolidated legislation, consolidating all these statutory enactments together, enabling the smooth flow of the legal regime relating to companies. The recent one, as I mentioned, number 17 of 1982, that was replaced by the Companies Act of 7 of 2007. This new law is a follower of the Canadian and New Zealand versions of the company law. Now let me look at the nature of personality in a company. We know that we are human beings. We are biologically made. We are made of blood and flesh. We have been born and we will die. When we die, we will have no existence. But however, a legal person will not die or will not cease to exist. A legal person will always exist forever until such a legal person is legally dissolved. So who is a person? A person would mean a human being like us, or a creation by statute, someone created by the law, and includes natural person like us, or a juridical person, a person created by the law. In nature, in extending also to associations. Associations mean a group of people or group of associations. In fact, even the partnerships, where the partners come together individually to form an association or a partnership. Then the companies, what our primary focus is on today, the legal person created by statute, having distinct personality apart from the natural persons involved. Organizations such as clubs or other entities of governmental and non-governmental nature, firms such as law firms, accountancy firms that are run by individuals with personal liability being taken, legal representatives, those who represent others or other organizations legally under agreements or verbal, written pieces of documents. Even the states I mean the countries are also considered as legal persons. And all these things fall within the meaning of a person. Having its own personality, having the liberty to operate within the parameters set forth by its formation and other related laws and regulations. Now, next question is, what is the difference between a natural and a juridical person? As I mentioned to you earlier, a natural person is a person like us, what we call a biological person, born with flesh and blood and existing in its natural sense as a human being. But however, a juridical person is a person created by the law, either by a statute or a charter, by which the existence of it derives from the law that creates it, and the existence will prevail until the same law ceases it to exist. The difference between a natural and a juridical person is that a natural person can physically move, whereas the juridical person has to be physically moved. Because, as I mentioned here, the company, for example, is moved forward or backwards by the persons who are involved in it. So, whether a juridical person exists or cease to exist would depend on how the persons involved in it, in that juridical person, will want to move it. Now, take the example of a position such as a king or a queen. When a king or a queen dies, it is the natural person who dies, but not the juridical person. The juridical person will be replaced by another natural person, so that the juridical person will continue, which means that the position of the queen or king will continue, whereas people, natural people, will come and go to this position. That's why we call it, when a king dies or a queen dies, we say the king is dead or the queen is dead. And immediately we say, long live the king, long live the queen. Why? Because there's a replacement that comes to that position, and so that the position continues. This is the same, in fact, with regard to the Pope of Vatican. When the natural person representing the position of the Pope, the natural person may die, but the position will not die. The position will continue. As I mentioned about the queen and the king, the monarch, we can say the Pope is dead, but long live the Pope. Whereas the replacement will take over the position and the position continues. This is the same with regard to company. When person A or person B leaves this organization, the organization will not die. The organization will exist with new people coming in to that position. New people coming in as shareholders of the company, having been bequeathed with the shares that A or B or A and B have been holding. But however, even a juridical person can cease to exist when the natural people involved in that juridical person moves it for a cessation in accordance with the law that created it. Companies take the same effect. So let us look at what is an association. Coming together, any group of people who have joined together for a particular purpose, having commercial or non-commercial objectives, with a body legally established or not in the nature of an organization, partnership or company. So an association in broad sense includes group of people, which means that at least there have to be two people joined together for a particular purpose. The purpose for which such an association is created, and the purpose or purposes that are mentioned in the creation and existence of such an association. The purposes are to be stated and thereafter be modified from time to time, having commercial or non-commercial objectives, either being business oriented or charity oriented or other social means of support oriented. With a body legally established, that is to say that the body is established in accordance with the law. With the law in the sense that presently it's the statutory law or the legislation that applies. With regard to an organization such as a club, partnership, such as a shop or other business or a company created by the Companies Act, or rather the Companies Law. My next question is, how does any association or alliance is formed? How do you create an association or an alliance? It can either be made by way of a statutory provision, as I mentioned, legislation, or by registration alone, consisting of a group of persons or companies. Now, generally, a company is created under the legislation that enables to create a company, such as the Companies Act, or by registration, such as a business partnership registered with a certain regulatory body or an authority that registers and give the full force of law to exist as a partnership, consisting of a group of persons or companies, whereas such particular association can be a group of persons, such as a company or a partnership, or such association can also be a mixture of persons and companies that create another company. So that some companies could hold shares of another company and exist along with other persons as well. There are many models that can be provided as examples in this, and we see that there are many companies, from mere private companies to public companies to even holding companies and to other statutory bodies that can be or that can fall within this definition. Having common objectives. The objectives to be agreed either verbally or in writing. However, in the case of a constituting of a company under the companies law, you need to lay down the objectives of the companies in its constitution, or what we call the Articles of Association. As means of original formation or merging. How does any association or alliance is formed? Is where, as I explained, these people or companies join in together to form such a thing as provided by the law. Now let us see what is a body corporate. A body corporate, according to Lord Lindley, an association of many persons who contribute monies worth to a common stock and employs it in some trade or business and share profit or loss arising therefrom. These may include public, private, public-private, onshore, offshore, etc. and etc. Let me clarify this. What Lord Lindley mentioned is that a body corporate is an association of many persons, at least of two in numbers, who contribute money and invest in such worth to a common stock and create a common stock and employs it in some trade or business, and whatever the share that they invest, they are entitled for the profit in by way of dividends, what we call in legal terms, and even the loss such company makes in its operation. These may include public companies that are mostly the companies created by the state or the crown, having a personality, legal personality that represent public interests. Then pure private companies that can be formed by private individuals. Then a mixture of public-private, such as the public-private partnerships that we are talking about. A joint venture, means of doing and furthering business. Then onshore companies, that is, there are the companies that are created on land, and offshore companies being companies that exist beyond the land. Let us now distinguish the personalities, the different personalities involved in this sector. If you look at the natural persons against associations, a person being an individual of biological means with a given identity, and an association being a collective initiative of a group of persons or companies or both in a mixture with defined identity. So, natural person on one hand is a biological person, and an association could either be collection of these natural persons or mixture of natural persons and companies, or even companies and companies. And then how do you distinguish an association and partnership? An association of two or more people engaged in a social or business enterprise having a common objective or objectives, holding co-ownership, especially in a business activity, with each partner holding responsibility and liability on joint and several basis, where the people associate together and form a partnership, and the partnership is formed for common objectives or objectives. Whereas, when the objectives differ, the partnership has no existence. The partnership collapses. So, that is why when a partner leaves a partnership or a partner dies, there cannot be replacement, because the objective diminishes in that case. So, when the objective diminishes, a partnership cannot go through. So, partnership remains as long as the co-owners in the partnership exist together for these common objective or the objectives, and they also hold the liabilities personally, responsibilities, and they are jointly liable as well as they are severally liable. Severally liable meaning that in case when one person is missing, the rest of the persons in that partnership or in the association are liable even for the liability of the missing person. What is a partnership and how does it differ from a corporate entity? As I mentioned to you, partnership is an association of people that come together for a common objective or objectives, but keep their liabilities and responsibilities to themselves, whereas corporates are formed by the individuals but operate distinctively from these individuals that form it. So, it is a creation of persons, partnership is a creation of persons and hold individuals responsible, while a corporate is a creation by the law with individuals holding the shares, where corporate holds distinct liability outside the shareholders. Corporate, shareholders and directors. Who are they? How do they differ? Or what are their roles? A corporate or a company is distinct from its shareholders, as you now know. They could be creators, they could be directors of the company appointed by the shareholders, but however, they are liable only in event of their personal wrongdoing. Otherwise, it is the company that is liable by its own. It exists separate from the persons involved in the company, but however, if the persons have done anything wrong to the company, then it is not the company that is going to be liable, it is the persons behind this veil of incorporation, what we term it, become liable due to their own personal wrongdoing. So, on the veil of incorporation, I will speak later once we first get to know more of the subject matter of companies. Corporate personality and the company law. Now we know that a corporate body or a body corporate, what we term as a company, has a distinct personality separate from its creators, shareholders or directors. What is a company in law? A company is an association or a collection of individuals, whether natural persons, legal persons, or a mixture of both. It acquires the characteristics, nature of being a legal person, having the right to sue and be sued, likewise a natural human being. So it's called an artificial person. So within the context of this interpretation, we could see that a company can exist having created by individuals, natural persons, or natural persons and some other juridical persons such as companies. And it has or it obtains a legal personality to exist as a distinct person. So whereas in this example we see that in terms of the word person, there are three persons: person A, person B, and person C being the company. Another important characteristic of a company is that a company can sue in its own name and can be sued in its own name. Which means that, for example, an outsider D who has a claim against the company can sue C directly and need not sue A and B, because C has its own distinct personality to be legally recognized as a person, as I previously mentioned, and C, having this distinct personality, is subjected to be sued. And it can also sue, in other terms, anyone in its own style and name. So this is actually artificial person, which is a creation of the law, but however, having the same type of title like those individuals, natural human beings, to sue somebody or to be sued by somebody. So is it same as its shareholders? Is a company same as its shareholders? No. As we know now, company is a distinct body. Shareholders, being the creators or those who are running the day-to-day business, operate distinctively, so that the company has its own existence. A company is a distinct person operating separately from its shareholders, though it has no existence without the shareholders, because it cannot exist without the shareholders. But having the shareholders in it, it can operate separately from the shareholders, but remains as a distinct person in law, having the power to represent itself before the law. Classic example is the Solomon versus Solomon and Company that I will take you through later. Can a company sue and be sued in its name? Obviously. Now you know the answer. Yes. Being a legally recognized person before the law, it can sue and be sued in its own name, irrespective of being represented by its shareholders or directors. As I very clearly mentioned here, the incorporation under the law of the state in which it is registered enables it to be identified as a person who is legally created and termed as a judicial person. Now, there are two types of creation of companies in this world. The common law type, what applies to Sri Lanka, is the existence of a company obtains from incorporation. In civil law countries, it is by real seat. By the fact that a company sits in a certain country, it obtains the personality what it requires to be a distinct and separate person having a legal personality. But whereas in the common law system, like in UK and Sri Lanka, it is by incorporation that a company obtains the required legal personality for itself. Now, let me take you through the landmark case, or what we consider as the pinnacle case law in the company law, which is the Solomon versus Solomon and Company Limited. Now, what happened in this case is that a man called Solomon in the UK started a leather shoe production business that later became very successful, and due to business expansion, Solomon established a company called Solomon and Company Limited. So earlier it was a sole proprietorship converted into a company, of which he took 20,001 shares for himself and bestowed 6 other shares among the family members, 1 each. The company also gave Solomon 10,000 worth debentures, which is a secured loan, for a secured loan, a facility given by the Solomon to the company. Soon thereafter, the company ran into bankruptcy and was left only with 1,055 worth of assets, pounds, 1,055 pounds worth of assets, with an outstanding debt of pounds 7,773 against unsecured debtors, who argued that they should be paid by the remaining assets, leaving Solomon out. Now, what happened here was that at the time of bankruptcy, there was a debt of 7,773 pounds against unsecured debtors who have not obtained any security from this company for the amounts that the company owed them. And also, the assets were 1,055 pounds. So this was the remaining assets for which you need to pay off this as well as Solomon's loan. Now, the difference between the unsecured debtors and the Solomon's loan was the Solomon took debentures which provided him security in the company, so that at the time of a bankruptcy or at the time of winding up and closure, the secured debtors have to be paid first. But however, the unsecured debtors argued that they should be paid first, but the court did not consider that fact because Solomon has given the 10,000 pound worth of loan facility based worth debentures on secured manner. And because of that, Solomon stood higher in the case of payment from the remaining assets. But now what the unsecured debtors argued, that Solomon is same as Solomon and Company because it was Solomon who created the Solomon and Company Limited. So therefore, it is his own company and he should not be paid for the outstanding debt owed to him because he is the company. The court rejected this argument on the basis that Solomon was an outsider of Solomon and Company Limited because Solomon and Company Limited was a distinct person from Solomon and the family members. Though he was a shareholder and the company has had its own legal personality outside Solomon. It can be that Solomon is a shareholder, but the company is a distinct person to which Solomon has given the loan facility. So therefore, since Solomon held debentures worth 10,000 as secured loan, he should be settled with the remaining assets, what we see here as 1,050 pounds, though he make a loss of nearly 8,800 or so remaining assets of the company prior to the settling any unsecured debtor. The court upheld the doctrine of corporate legal personality that a company is independent from its shareholders. But however, it should be reminded that here the Solomon at the time of bankruptcy will not be eligible to his share of the shareholding, but as a means of a debenture holder for a secured debt, he has an entitlement towards the remaining assets of the company against his loan, because Solomon is not the Solomon and Company Limited. Let us now see the characteristics of a company. There are mainly three types. Companies limited by shares. Companies limited by shares means that the company has been created by the shares and the shareholding of that particular company invested by the shareholders liability is limited. Under section 3 subsection 1 subsection A of the Companies Act, a company that issues shares, the holder of which have the liability to contribute to the assets of the company, if any, specified in the company's articles as attaching to those shares, which means that the shareholder is limited of its liability to the number of shares that the shareholder subscribe in the company. So in case of a closure or bankruptcy or winding up of whatever, where the company is to be ceased, exists to cease, then the liability of the shareholder is limited to the number of the shares that he has subscribed in the company and to the amount of the per share value. Now, example ABC Limited, which means that the company's liability is limited by shares. So that the company is limited by the number of shares that are being created at the time of formation. It can be a public company such as ABC Limited. It can be a private company such as ABC Private Limited. And it can be also a listed company such as ABC PLC. The second type of companies are the companies that are that have unlimited liability. Now, the limited liability companies are much an abundance, and unlimited companies are very seldom in existence. You don't find much unlimited companies nowadays. Section 3, subsection 1, subsection B says, a company that issues shares, the holder of which have the unlimited liability to contribute to the assets of the company under its articles at the time of bankruptcy, winding up or ceasing to exist. Such a company is called an unlimited liability, or a company that has given unlimited liability towards its shareholders, so that the shareholders become liable without any limit. So that example ABC Unlimited in the case of a public company, or ABC Private Unlimited, which is of a private in nature. As I mentioned to you before, the existence of which are not so nowadays because of the liability aspect being unlimited. The third situation is where the companies are limited by guarantee, where the shareholders provide a guarantee towards the company that in case a company cease to exist or wind up or bankrupt, their contribution is guaranteed towards the assets. So, section 3, subsection 1, subsection C says, a company that does not issue shares, the members of which undertake to contribute to the assets of the company in the event of being put to liquidation in an amount specified in the company's articles. So, such a company can be titled and named as ABC Guarantee Limited as a public company, or ABC Guarantee Private Limited companies. However, these types of companies do exist, like the other limited liability companies, though we don't see that much of unlimited liability companies nowadays. Now, I would like to explain to you how companies are created. First and foremost, a company is created by the activities that a particular promoter or an initial investor is going to form a company. That is the starting point. The promoter is a person or a party to the preparation of the prospectus of the portion thereof containing the untrue statement, but does not include any person by reason of his acting in a professional capacity for persons engaged in procuring the formation of the company. So, the promoter along with the prospectus is the initial person who forms a company with the intention of forming it and proceeding towards incorporation. Taking the first step, the promoter promotes the formation of the company or the constitution of the company, and thereafter invite others to join and invest in this company. In Troy-Cross versus Grant, a promoter was defined as one who undertakes to form a company with reference to a given project and set it going, and who undertakes the necessary steps to accomplish that purpose. So he is a person such as an offeror in contract law that offers a certain business opportunity for those who prefer to invest in such a company, and thereafter forms the company in accordance with the law. He is responsible for raising capital, targeting initial leads and chasing initial business opportunities, entering into initial contracts for the formation of the business and incorporating the company. And he acts similar to an agent, though he later might take up the position of being a shareholder, director, so forth. But for an organization that is not formally incorporated, that he is acting for an organization that is not formally incorporated. So therefore, at initial stage or at foremost, a promoter engages himself to call for offers or intending his offer be accepted by offerees in the formation of a company. Therefore, he naturally enters into such contracts either by way of his own offers or by way of any count offers that come to him as offerees. So he enters into what we call pre-incorporation contracts. The contracts that are being entered by the promoter prior to any incorporation of a company. The types of contracts that are used where the promoters have to obtain properties or secure other rights and obligations as a prerequisite to the incorporation of the company. He may have to enter into agreements to acquire property. He may have to enter into franchising or distributorship agreements anticipating the formation of company that may tend to exist in the future. As per Kellner versus Baxter case, pre-incorporation contracts were not recognized and had no legal effect. The prevailing law with regard to the legality of pre-incorporation contracts was that the pre-incorporation contracts did not give any legal effect to the company that will be formed in the future time. And the company that is formed later on will take no responsibility or liability for any acts, undertakings or liabilities that the promoter carry along with him. But however, this position of the common law has now been changed under the Modern Companies Act, thus recognizing and giving the legal force so long as the promoter provides implied warranty as to the formation of the company on specified time within reasonable period. Which means that under the present legal structure, whatever the promoter enters into anticipating the formation of a company in the future, the promoter is secured that whatever the promoter undertakes or deliver in anticipation of the formation of a future company, he will be relieved from any liability, because the promoter provides an implied warranty as to a formation of a company in the very near future or within a reasonable time period. Now, what means is that the promoter gives an implied warranty that a company is to be formed at a very near future or within a certain reasonable time period. So, the qualification is that the company is to be formed within specified time or within reasonable period. If the particular company is not formed during the specified time or within the reasonable period, that the promoter provides the implied warranty to others with whom he is contracting, then in that case, promoter becomes responsible and liable as per the old prevail law. But the position of Kellner versus Baxter has now slightly been changed in order to provide the promoter some sort of a security and safeguard that the contracts that he is entering pre-incorporation with others be legally valid as against the company when the company starts to operate and exist. Let us look at this question, which is relevant and related to the area that we discuss about the promoters. Now, here in this question, Ali and Benny were the promoters of a company that deals in electric motor vehicles. Prior to the incorporation of this company, the promoters entered into a contract on behalf of the proposed company for the purchase of 75 electric three-wheelers. What you are required to do is to explain how the above contract can become binding on the company when the company comes into existence with reference to the provisions of the Companies Act. State two duties applicable to Ali and Benny as promoters in relation to the given scenario. Summarize three methods that Ali and Benny as promoters can utilize to reimburse the cost incurred by them to incorporate the company and to obtain the payment for services rendered by them. Now, let me explain to you first of all the first one. How do you answer this? Explain how the above contract can become binding on the company when the company comes into existence with reference to the provisions of the Companies Act. Now, what you have to explain here is that first of all, who is a promoter? What a promoter can do in situations of a pre-incorporation situation. What sort of contracts or activity that he can get engaged. Then thirdly, what are his entitlements under the Companies Act, number 7 of 2007. So, we earlier discussed that he could enter into contracts on a pre-incorporation status, but within a specified time period and within a reasonable time period that a company could come into existence. And also you could compare that the law has slightly differed now from the common law of Baxter versus Kellner, right? And that now the law provides promoters some sort of safeguard and security in relation to pre-incorporation contracts. So therefore, you are required to explain that situation and come to the conclusion that the above mentioned contract of purchasing 75 electric three-wheelers prior to the incorporation, the company later on what comes into existence will take over the liability to fulfill the purchase contract that Ali and Benny had come into. Secondly, the question asks, state two duties applicable to Ali and Benny as promoters in relation to the given scenario. Obviously, they have to act in good faith. Good faith for the purpose of bringing in the company's existence within a certain specified time period or reasonable time within which the company has to be created, and also being promoters of the company, they must operate and work for the benefit of the company rather than to the detriment of the company. So that they must have a clear idea as to what later on the company will have to bear as of a responsibility towards the contract that they have made. The third question is to summarize three methods that Ali and Benny as promoters can utilize to reimburse the cost incurred by them to incorporate the company and obtain payment for the services rendered by them. Three methods that Ali and Benny as promoters can utilize. That is, first of all, they need to enter into a proper contract to purchase these 75 electric three-wheelers. And we know that they cannot come into a contract in the name of an unincorporated company, because that contract will not be valid. So there has to be a contract in the name of Ali and Benny that they purchase these bicycles, three-wheelers, I beg your pardon, and thereafter to convert this liability on the company that they intend to create. So in that case, they have to utilize those things, mechanisms, and thereafter allow and make provision for the company to bear these costs of the three-wheelers, that later on the company will assert these assets to that company and relieve Ali and Benny from their personal liabilities and responsibilities. So this is how you need to approach this question when it comes to promoters. Now, let us approach the next area, which is the real incorporation of a corporate company. How do you incorporate a company in Sri Lanka? Under Section 5 of the Companies Act, you need to duly fill the relevant application that you obtain from the company registrar. However, beforehand, you need to obtain a clearance for the company name that you intend to put in the company's creation. So I will come to the prerequisites that you need. First of all, the company name to be approved by the Registrar of Companies. When you apply for a company name, the company name needs to be checked from the Registrar of Companies, or what we call the ROC, to see whether there is any existing company in that name. If there is any existing company in that name, you will not be allowed to use the same name. Or there can be sometimes similarities in the name that you use for your company with certain existing company or companies. And on the discretion of the register of the companies, when there are similarities, especially with regard to the language or the way it is pronounced, such a company or such a succeeding company will not be allowed, successive company will not be allowed to be registered until you make certain amendments to show the difference between the existing company and the company that you intend to form. There are various instances, or several instances rather, that we have come across having very similar names and titles. And for that reason, there have been several cases, legal matters that have aroused with regard to the legality and the existence of such successive companies that conflict with the prevailing company names. So because of that, the company name will be checked first, and also primarily the company name should not contain an existing company name or misleading in the opinion of the registrar, and also shall not have names such as Chamber of Commerce or President or Presidential, Municipal, Incorporated, Cooperative, Society, National, State or Sri Lanka. So these later mentioned specific terms and names cannot be used in companies. But however, we have seen nowadays, even though the name Sri Lanka cannot be used, people tend to use the term Ceylon, Lanka, which are not prohibitive under the prevailing provisions. And once the company name is approved, then you need to create what you call the constitution of the company. We call it the Articles of Association. Articles of Association will lay out the company's main business areas, objectives, the powers of the shareholders, shareholding, the capital, the eligibilities of directors, directors' disqualifications, rights and liabilities of directors and shareholders, modes of winding up or dissolution of the company, and any amendments that can be made to the company's articles. So the company's article, what we call the Articles of Association, is a very important document. This is the primary piece of legislation that exists in a company, so that the company needs to run throughout its existence in line with the company's articles. I have seen some companies that uses a more general model of incorporation by means of articles. But however, the more specific one company can be is much better rather than having a general scope, because it will make sure that the company exists for the right purpose for which it has been created, rather than giving it a generality in scope. It would be much beneficial for the company to restrict within the objectives for which the company has been created. The Articles of Association is the primary document for the company's incorporation. Once the Articles of Association is given along with the required form for the incorporation with the Register of Companies, the ROC will thereafter proceed to register, incorporate the company, and issue the certificate of incorporation, what we generally call the registration certificate, but it is formally and legally called the certificate of incorporation. And the incorporation will carry a number to every respective company that it is registered with the ROC in Sri Lanka, and that is the main important identity for a company that exists under the Sri Lankan law. With the incorporation and formation, or rather the constitution of a company, the next important area is who is a shareholder of a company. A shareholder is a person or persons entered as holders of shares in the register of the shareholders maintained and submitted by the company to the Register of Companies, and must indicate the holding of at least one share by a shareholder. Now, shares cannot be of any division, such as a half or a quarter of a share. Always the minimum shareholding can be one share. And share is a movable property. Share is a movable property where it can be given from one person to another, unlike a land or a premises, which are more of immovable in nature. Shareholder is a person whose name is entered as shareholder in an application for the registration of the company. He who holds entitles to be entered in the share registry in an amalgamated company, person to whom a share has been transferred and awaiting entry or to be entered in a share registry, beneficiary of a trust for whom a share is held prior to entering such trust in share registry, or to whom a share has been transferred but has been wrongfully omitted from the share registry. Now, there are several meanings that fall within the term shareholder, and shareholder could mean any of these, and shareholder is the most primary important person in the company's existence, and shareholder is basically an owner of a company.